the type of issues that they run into when they're working with these outsourced call centers and other types of vendors. And I have worked with some of the ADT vendors on different types of compliance things that we do. So I'm pretty familiar with the process they have, and it's pretty well done, but I think it might be a good idea just to maybe start with a description of that from your perspective and put some context.
Sure. So I'm with the ADT. We are the largest alarm company in North America. We operate in the U.S., Canada, Puerto Rico. We've got about 17,000 employees, 8 million customers, and a ton of telemarketers. So we have in-house telemarketers who call on our behalf to sell products. We also have third-party dealers that are independent companies that will sell ADT systems. So like if you go into a Best Buy and you buy a Sprint phone or a Verizon phone, you are buying the phone from Best Buy, but the contract for the service goes on to that company. So like that, we have independent dealers who sell on our behalf, and some of those are approved to telemarket on our behalf, so we have to. And then we also do a number of other non-telemarketing calls, but important calls nonetheless. So if your alarm goes off, we're going to call you 2 times, once on maybe your home phone, once on your cell phone, to confirm that there is an emergency situation there, and do we need to send the police or fire or medical. And so those are all the types of calls that we're dealing with, and each one has unique constraints and different opportunities for us to stumble. And so we have a really top-notch compliance program that was brought on, and I'll be forthright about this. There was some sort of an order, it was before my time with the FTC, back in 2004, and we adopted this, what we consider to be the gold standard of compliance programs. And even though the time that we were required to do this has expired, we continue to do it because we believe it's the right thing to do.
What's interesting is I'm sitting here listening to you and all the discussions about the robocall blocking and labeling. It's interesting to know that if any of those types of calls will be an issue with that, maybe you can pay attention to that issue for
That's something that we're definitely, I made a note about that.
Yeah, okay. Well, but we digress. So, you know, our goal today is really to describe what agency theory is for purposes of vicarious liability and under what circumstances that type of relationship can form to provide liability up and down the marketing change. We're also going to talk about the status of vicarious liability and the definition of agency within the FCC. It's been evolving here a little bit lately. And then we want to provide some concrete methods that you can use to help avoid agency situations from being formed in terms of relationships where you didn't intend to have somebody be your agent or you didn't intend to be an agent. So hopefully you can leave here with some practical advice on those types of things. So let's just start by looking at the kind of sum total of the vicarious liability universe for purposes of what we're talking about today, because it does go beyond just the FCC. The FTC obviously is the federal agency that initiated the lawsuit against Dish Network that ultimately ended in this $280 million judgment earlier this year. And the FTC has looked at the concept of vicarious liability both in terms of their FTC Act. I've done that twice now. I'm so sorry, guys. I'm going to hurt your ears before they're really bleeding by the time we're done here. And Nick said that I was going to do that. He did call that. Gosh, where was I? So the FTC, along with the state AGs, brought that lawsuit as Lois described, but the FTC Act that prevents unfair and deceptive acts or practices has this concept of vicarious liability in it, as does the telemarketing sales rule, which specifically uses the terms assisting and facilitating. So the FCC, in a number of decisions over the last several years, has put some meat around this concept of assisting and facilitating, and when there can be that type of vicarious liability. So I don't want you to forget, as we're focusing on Dish Network and specifically on the TCPA, that there are broader concepts within the FTC. The FCC, we tend to worry about a little bit more because of the private remedy and the potential for class actions. Generally, that's the bigger concern. Dish Network had a little bit of a different issue because of their challenges with the FTC, but that's generally where we're most concerned about it. And because of the TCPA violations that were alleged in the Dish Network case, the FCC was called in to render some guidance and issue a declaratory ruling. So we're going to talk about that. So we're worried about also this context of the FCC's view of agency theory. And then the states largely mirror some form of what the FTC and the FCC says about vicarious liability. So I don't want you to think that this is just limited to federal types of issues. That state AG panel that was up here also believes that they have the ability to bring enforcement actions, not just against the person who made the call, but also the seller, and then vice versa, the seller to the person who made the call. So I think it's probably important to explain the Dish Network background a little bit so you know the facts behind the case, because I think it really colors what happened to Dish Network and why this penalty, the civil penalties, were so large in their case. The Dish Network group of what they call order entry retailers, that's what they called the people that were making telephone calls on their behalf, they considered them independent dealers. They were called independent dealers of Dish Network. And in the contracts that Dish Network had with I'm going to call them OERs, that's what they call the case, order entry retailers, that they had with the OERs, those contracts specifically disclaimed agency theory. So understand there was a contract that specifically said with all of these entities that there was no agency between them, and the court did not pay any attention to that clause, or they basically discarded it, saying you can say that in a contract, but it may not reflect the actual situation. So understand that was part of the contract. Also in that contract, the court pointed to the fact that Dish Network had the unlimited power and ability to impose what was called business rules with their OERs. So they could come up with a business rule for how these marketers needed to market, and they could impose it. And the court said for no other reason than because Dish Network said, because I told you to. So while they disclaimed any type of liability in the contract, and tried to take a hands-off approach, at least to litigation, to how they were managing those folks, the contract spoke differently to their ability to impose rules on their OERs. There were numerous, so when I say numerous, I say hundreds of thousands of complaints over the course of 2003 to 2017, which is the sum total of the length of this litigation looked at, that Dish Network received about telephone calls that were being made on their behalf by their OERs. And the standard response that Dish Network took to those complaints was that these are not us, we're not placing the calls, these are independent dealers that are selling a Dish Network service, and if you have an issue with that call you received, or if you're on the do not call list and still receiving a call, then you need to go to that dealer. And they have what they called a standard letter, and then they would insert the vendor's name in, or the OER's name in, that would go out to let the consumer know that it wasn't Dish, it was this OER that was responsible for it. The court pointed to that and said that the individuals within Dish had a conscious disregard for the seriousness of what was going on, and they chose not to investigate to the full extent that they could have what those complaints were the result of and what was causing them. Another interesting thing, I just thought from a business perspective, you guys would understand this and find this interesting. Some of these OERs were very unscrupulous. They were making robocalls in the true sense of pre-recorded messages that were illegal, pre-recorded messages to hundreds of thousands of people in a short period of time. And one of the other things that they were doing is you could not enter into the Dish Network system in order for Dish Network unless there was a credit card that the consumer provided to charge in order to activate the Dish Network. So what some of these OERs were doing was they were going out and getting prepaid cards that had $1 on them and entering that card number into the system so that they could activate a system. Obviously, they were paid on commission for the sales they made, so there were some bad actors here. So when you start to lose sleep over things, and yes, vicarious liability is something you should be concerned about, you really got to think about the facts that the court was looking at when they came up with this decision. The lack of a compliance program, the lack of taking responsibility for the people that were marketing on your behalf, accepting the benefit of all those sales that the marketers were making on their behalf. Also, Dish was aware that there were sub-vendors, that some of these OERs were using to place telephone calls that they had no control over, and a lot of circumstances, the pre-recorded messages were coming from these sub-vendors. And the court just found a conscious disregard for how Dish Network was handling their compliance and the issues that were identified. In 2009, Dish entered into a multi-state attorney general settlement that involved 47 of the AGs. I'm sorry, maybe it was 46. The other 4 states are the ones that were with the FTC in this lawsuit. One of the things that the courts in the Dish cases also looked at is in that assurance of voluntary compliance that Dish Network signed with the states. They said they had the ability to impose compliance standards on their vendors, and that they would do that in the future. And that was one of the reasons that the settlement with the AGs was a much lower and less intrusive settlement. And the court pointed to that, saying, you said you could control them, and because you said you could control them, there's an agency, a likely agency relationship there too. So I just wanted to give you a background. So let's talk about what these concepts are and where this case law comes from in the vicarious liability world. In 2013, the Dish Network case was in full litigation mode. The case has been filed in 2009. There were questions that were coming from the AG's offices that were involved in the litigation, as well as the FCC, about this concept of liability for a seller under the TCPA when the seller did not make the call, but the call was physically made by other persons, by marketers. And so they requested a declaratory ruling from the FCC. We're going to talk about that in a minute, but that's where we really started paying attention to this concept of vicarious liability. And ultimately, the court used that decision when issuing its judgment against Dish Network earlier this year. Also, I just wanted to point out, so the 2015 omnibus ruling did a lot that we are unhappy about. But one of the things that's often overlooked is that the FCC also talked about this concept of vicarious liability in that declaratory ruling and reinforced what we're going to talk about here in a minute that they had done in 2013. And then, of course, most recently in the vicarious liability world, we have the Dish Network case, which is the purpose of our presentation today. So what did the 2013 declaratory ruling said? It said specifically that while primary liability under the TCPA lies with the person that physically made the call, the person that places the call, that a seller can also be vicarious liability under a common law theory of agency. So that was the first time that we really saw in the vicarious liability world what the FCC thought it would take to impose liability to a seller. They talked about 3 different kind of concepts of agency that could extend that liability. The first one was a formal agency relationship, and under the formal agency relationship, they're talking about an actual contract or something that formally establishes somebody as your agent. That's the clear-cut example of how we're going to find that agency relationship. So not really a lot to talk about there. It's something that you've held these people out as your agent. It's in a contract. It's something definitive that you can point to. What causes us a little bit more pause and to scratch our heads and to try to ferret out what exactly we're talking about beyond a formal contractual or other relationship for agency is this concept of a parent agency. So this would be a situation where there is no contractual agency, you're not holding them out as your agent, but you're doing the types of things that Dish Network did, and we're going to spend some significant time talking about that. And then lastly, there's this concept of ratification. And what ratification means is that even though they are not your formal agent, you have reaped the benefits of the actions that they're taking on your part. So basically, you're getting sales from them, and you are ratifying their behavior by accepting those types of sales. So,
Michelle, it might be interesting to just point out, there's a case that it's recently hit my radar with Honeywell, where they were recently brought into a vicarious liability lawsuit with the security industry. So Honeywell manufactures many of the security panels that companies will install on the walls. So there was a company who had, I believe, third-party dealers, independent dealers, selling security contracts, and they were installing Honeywell equipment. and they were found to have violated the TCPA, so they brought in the individual dealer, the company that was buying the contracts from the dealer, and then Honeywell, the manufacturer of the equipment that gets put on the walls, that has nothing to do with how they're marketed or sold. So that I recently saw an amicus brief that was filed on their behalf by the U.S. Chamber of Commerce, the security industry, and the National Association of Manufacturers. Because if you think about how that has the potential to just build on vicarious liability, it could be anybody.
I have to tell you, I deal with a lot of class action attorneys, I deal with a lot of plaintiffs' attorneys in my everyday work, and the theories that they have espoused, similar to that Honeywell, that because they're selling the equipment, and by selling the equipment, they're reaping the benefits of that sale, and thereby ratifying any bad behavior of the marketers. I mean, they say this with a straight face and emphatically that that's the case, and I mean, you couldn't think of anything more distanced than, selling something that's a physical product, but they have no idea who's selling that, except that people are selling their services. And imagine the liability that causes for any product sold out there. I mean, it gets to...
someone with a Louisville Slugger bat, does that make them liable? I mean,
only under the TCPA. Yeah, there. But, the other interesting thing, though, in the context of talking to these plaintiffs' attorneys, so, we'll use that a little bit to our benefit as well. So I had a case where there was a seller that was the deep pockets in this case, and we were representing one of the vendors, or we were representing the deep pockets, and one of the vendors had some issues with Colin. We'll just leave it at that. And so as soon as the company was put on notice that there was an issue with this vendor, and we suspected there were other issues too, the relationship had to be terminated immediately. So, taking into consideration that type of ratification, if you take immediate action, that's been helpful with the plaintiffs' attorneys that we work with. I'm getting ahead of myself here a little bit. So let's talk a little bit about apparent authority. So apparent authority, as we said, is when there isn't an actual formal agency relationship, but based on a number of different things that are codified in a common law theory of agency, an agency relationship can be formed. Now, I can tell you that we spent probably weeks in law school on this concept of common law agency theory. It's not really something you want to try to spend a whole lot of time on, but you do want to make sure that your lawyers understand this concept and they know how common law theories of agency can be formed. When the FCC issued its 2013 declaratory ruling, they tried to define, to a certain extent, this concept of agency theory, and Commissioner Pai in particular was very critical of what the FCC did in its declaratory ruling, because they said, yes, while FCC, you have the ability to determine the concept of liability and what caused that, you, FCC, do not have the ability to define what a common law theory of agency is. So we see a little bit of disagreement, and also under what's called the Chevron deference standard, which allows an agency that's responsible for enforcing specific laws to provide guidance on that law, and that guidance is binding on certain courts. It is binding, the fact that they said that common law agency theory is what vicarious liability is under the TCPA, but not what they said is what is common law agency. There's a distinction there. They're not the agency that gets to enforce common law agency. So understand that there is some wiggle room, or not all of what is said in that 2013 declaratory ruling is the absolute law.
Yeah, I'm going to talk a little bit about some of the case law on that, and I think that bears out in the case law. So they look to the FCC's ruling on what the applicable standard is, but then they look to their own prior case law on vicarious liability and agency to determine whether that actually existed in that case. They don't give a lot of deference to the FCC's commentary there. So.
Yeah. This previous slide, when we're talking about some of the examples that the FCC gave in that 2013 declaratory ruling, these are the things that they pointed to specifically. And a big one, which was present in the Dish Network case, was that systems that are only usually available to the seller, so they're order entry systems that have all of their customer information and actually is the system where the sale is consummated through, that if that system is provided to a vendor in which they can access and enter their orders, that's one thing that they said would be more indicative of an apparent agency type of relationship. Also, if the seller is dictating pricing, the nature of the product, providing customer information, and the direct order entry, as I said, into that system, those are the types of things that would more likely point to an agency theory. If you're able to use, if a vendor is able to use a seller's trademarks, that also is something that would lend itself to an apparent agency theory. We get a lot of questions about this approved or wrote scripting. A lot of our clients are concerned that if they start looking at all of their vendors' scripts, that there's going to be an issue with increasing the likelihood that they would be found to be an agent. And I would just say that just the fact that you're reviewing a script is not going to probably take you that far, and Nick will be talking about cases. And you need to review the scripts for the people that are calling on your behalf. When it starts crossing over into the agency, apparent agency world would be if you were dictating exactly what the script has to say. It has to be read verbatim in the way that script is drafted, and you can unilaterally impose mandatory scripting, things like that. And it may not just be that one of those things is what causes an agency relationship, but you really need to look at them all in the totality. So, but please don't take away from this discussion that you shouldn't be reviewing your vendor scripts.
This last item keeps us up at night. Seller should have known a violation and failed to stop it. Because we've adopted such an enhanced compliance program, and we require of our third-party independent dealers that they sign up for monitoring with a company, and that company then has to check in on their calls to make sure that they're calling the right people, that they're not violating the TCPA. We've gone that extra step. That could be construed as us, we should have known. So because we've taken the extra step to enhance our compliance program, to drive down the number of unwanted calls, it actually makes us more liable for these types of things, which is unbelievable. But again, we do it because it's the right thing to do, and we think it drives down the overall number. But it's a tough decision for companies to make. Why invest all of this money into a program when it actually increases your risk of a lawsuit?
And it's such a great point. I mean, this really is a balancing act, and like I said, I think ADT has done a good job with that balancing act, with setting standards of compliance that they impose, because you can't impose a compliance requirement without going too far over into this apparent agency world. Because if you're doing those types of things, the chances of complaints are less likely, right? The issue that we have with Dish is that they were doing none of this, so the complaints were huge. It makes you a bigger target. You're more likely to run into regulatory types of problems. But I would stress the fact that contractually you can require your vendors to comply with the law, and that's not going to be something that is going to push an otherwise not apparent agency relationship into an apparent agency relationship. About that. I'm driving on a little bit here, so I'm going to move a little bit quicker. But it's really simple. Principles, you're liable for your agents. How simple is that, right? We're going to have lots of questions about this, but at the heart of all of this, that is what we are talking about. That sellers, when you are using vendors, if they turn out to be your agents, you are going to be liable for what they do. And these are the types of things that are hallmarks of an agency relationship. The court in the Dish Network case pointed to this concept of initial and ongoing control over those third parties, either contractually or by nature of the relationship. In the Dish Network case, it was this ability to impose business rules, the ability to affect the type of compensation they were getting for their sales. And Dish really did have control over those third-party marketers in a lot of different ways. They could turn on and off programs. The court had a pretty long laundry list of why they did have a tremendous amount of control over their agents. This right to control, the bullet point there about the agent must act or must agree to the right to control and act within the scope. That's kind of that concept that I was talking about with the contract with Dish Network, that they can impose business rules, and that also falls within the constraints. I think we covered that pretty well, the ratification. So if they're agents, then what? Is there a way that you can negate agency theory? Because remember, if we're talking about a parent agency, you didn't intend for, the seller did not intend for the vendor to be their agent. So are there ways that you can then argue that even if there wasn't a parent-agency relationship, that there, or it appeared to be a parent-agency relationship, that it actually was not. And so one of the things is this concept of acting outside of the scope of the authority, which is another good reason to put compliance principles in your contracts and to oppose those, because if they're acting outside of that scope of authority, and that is to call on your behalf in a way that is compliant, then that's one of the ways that you can negate agency. Also, if you didn't ratify the behavior, so that if you did not know and you didn't consciously avoid knowing and there was no reason that you should know, that they were violating the law, then you did not ratify their behavior, and there is no concept of ratification. So with that, we do want to talk about some of the common things we've seen. So after the Dish Network case, there have been several cases that have spoke to this issue of agency and vicarious liability, and they kind of ferret out some of the themes in Dish Network that I think help provide some concrete guidance. Vicarious liability.
So unlike some of the other areas of TCPA case law, I would say that the vicarious liability opinions are a little bit all over the board. So you have to really try to kind of parse it out, and it's so fact specific. So there's lots of factors that they're going to consider, and it might be one factor is just so in favor of an agency or against an agency relationship that kind of dictates. But we've done our best to kind of whittle it down. Before I get to the kind of common themes here, just real quickly mention a couple actual specific cases. One recently issued by the 9th Circuit involving an administrator of a vehicle service plan. So the way that industry works is you've got the obligor or the provider of a vehicle service plan. It's somewhat analogous to an insurance provider, and then they have independent third parties that market them. Typically they market on behalf of multiple providers of those service contracts. So the 9th Circuit was tasked with deciding whether that administrator was responsible for violations committed by one of the marketers, which, not surprisingly, was no longer in business. Basically what they said is, and certainly I'm paraphrasing here, but they said that control is the essential ingredient of a agency relationship. No surprise, you can go to the restatement of agency to find that out. But they also cited 9 other factors that would be considered when analyzing whether somebody was acting as an agent of the third party that you're trying to deem the principal. It looked at everything from the extent of control, as I mentioned. They looked at the amount of supervision that the purported agent was subject to. They looked at whose tools and instrumentalities. So in this case, they actually looked at whose computers and phones were used. They looked at whether there was a contract for a specific term, whether it was open-ended in nature, whether it was cancelable by both parties. So they listed 10 factors to be used, but at the end of the day, they said that the number one factor is, of course, is control. In that particular case, they determined that the service contract provider was not acting, was not the principal on whose behalf the third party was acting, because it didn't control the day-to-day business operations. It had certain compliance requirements in its contracts. It reviewed and approved scripts. It even mandated certain data security requirements, things that you would see in a typical vendor contract or some type of third-party business contract. But they didn't approve the day-to-day operations. They didn't mandate quotas. They didn't dictate how they marketed other than do it in a compliant manner. They didn't dictate how many hours they had to spend marketing and those types of things. So good case, I think, for the industry and some good takeaways that we can move forward with. Another case, real quickly worth mentioning, involved 3 of the prominent insurance companies, and this was a district court case, and the court dismissed 2 of those insurance companies because it found that the basic facts were each of those companies has licensed insurance. So some kind of key takeaways here. Michele mentioned this earlier, though. You can't throw a provision in your contract saying they're acting as an independent agent and think that that's going to be enough to avoid vicarious liability. It's not going to be your categorization. It's going to be just the actual relationship that dictates. The ability to control the manner and means of a third party's marketing. Again, this gets to the concept of, day to day, are you controlling, where they market, how they, when we're talking about scripts, right? If you're drafting their scripts from a sales perspective, that could be problematic. If you're just approving them from a compliance perspective, that's treated differently by most courts. This concept of interim instructions, so it's not just, again, enough to approve it up front, but you're giving ongoing approvals throughout the process, and again, typically more involved in just compliance related. To the extent that you're actually providing them the marketing materials, to the extent that you're coaching them on how to make sales, those are types of things that will be factored in and be an indicator that it might be an agency relationship. It's pretty clear. There's a case that went all the way up to the Supreme Court that involved kind of a chain of companies, and what they held was you've got a seller, they hire a vendor, the vendor hires a subcontractor, and the vendor that didn't make the calls, nor was its products or services promoted during those calls, but it can be held liable as well because it's in that chain. So again, you can't just contract the work out to somebody else and bury your head in the sand. One of the things that several courts have actually pointed to is, well, this particular company was generating leads for lots of different companies within the same industry. So let's say it's home security and they're generating leads for multiple different companies. That's less likely to be an agent. Let's say it's the financial services industry. You see that a lot with some of the prominent agent sites. They generate leads. They provide those leads to multiple third parties. Again, less likely that they're acting as your agent. And then in terms of, Michele kind of got on this a little bit, but when you're defending against a lawsuit, the first argument you're going to make, of course, is they were not acting as your agent, they're an independent third party. If you lose that argument, then you're going to next argue that they were acting outside the scope of their authority. You can't be held responsible because even if they were your agent, you didn't authorize them to do that particular act. That's where contractual provisions can come in handy. You need to make sure that you're thoroughly vetting your contract, you're having good provisions in there, at least on that line of defense. It's not the end-all be-all, but it's certainly one piece of the puzzle. And then the ratification issue is part of that equation as well. So you need to do due diligence. I think there's good case law supporting that you can have some hands-on approach when it comes to these third parties without crossing that line. And that due diligence will be an important component when you argue that you are not responsible for their unauthorized act. So I know there's a lot, but from a proactive compliance standpoint, I think there's 2 things that you're going to take away. It's that you probably want to be cognizant of not exercising too much control over them, especially with marketing, but still do those checks and balances from a compliance standpoint and some limited capacity with the due diligence program. And then when you actually find out about those violations, you have to do something about it. This is the perfect example. There are others that you, by kind of standing by and doing nothing, you just really increase your exposure.
And just to follow up on something I said about the plaintiff's attorneys that we deal with, they have Google alerts set up for when various cases are filed, and they have a platform called Law 360. And one of the plaintiff's attorneys said to me, well, because these things are being reported, your client should have Google alerts set up so that if a lawsuit is filed, they're made aware of that. So it's a good idea, I think, to set up those types of Google alerts for your vendors. Do you guys do that? I'm curious.
I don't know.
Yeah.
It's on the government affairs side. I hope somebody does.
Yeah, I'm sure. I would be shocked if they did.
From the new generation perspective, we love to crack down on the people who like to unleash the torrent of robocalls in the middle of the night, pretending to offer ADT services, and then offering another security companies once they actually come to your house. That's a different issue for us.
So then brings us to kind of what's next. And ADT has been a great partner in working on games and things like that.
Right, so we've been working with PACE, and I think many of you on this week. Last year, I'm optimistic that this is going to get better. I think there's a real opportunity to make this workable and to bring it back. I think to rein it in, to make it the law that it was supposed to be. And I think one ray of light last year, or maybe it was the year before, Senator Daines from Montana introduced an amendment. It was not adopted, but it was sort of a test balloon to see how people would react. And it said, basically, these are the ways that a company could, if they're brought into a court case because they've been accused of being vicariously liable, these are the ways that they can prove that they are not vicariously liable. If they've implemented a compliance program, if they are doing sort of the types of things that selfishly we are doing, but if you have things in your contract that say that your vendor has to follow the law, if you have checks and balances in the contract, if you find out that the vendor is violating the law, there's some sort of there's some sort of a penalty to that vendor. So either the contract is canceled, but there's some sort of a penalty for that, the person who was violating the law. But if you have these measures in place, you could put forward an affirmative defense. So it's not a safe harbor, but if you're brought into court, it's a way to get yourself out. And we think that it would actually incentivize more companies to adopt a robust compliance program, because it's more of a carrot as opposed to the stick. Right now, we're all afraid to do a little bit extra because we could be found to be vicariously liable. But think about if everyone was encouraged to adopt this sort of thing, I think more companies would adopt these sorts of measures. So we put it forward as an amendment. In the past, I think there have been attempts to water down the TCPA, and it is not well received. This did not receive that same cold shoulder. People were just like, okay, and then we waited, and nothing happened. There was no blowback. So we were taking a look at this year, what should we do? Should we introduce legislation? Should we try to get this codified? But there's also the opportunity, what if we would go to the FCC and ask, you've said that these are the ways that a company can be found to be vicariously liable. What can a company do to avoid attaching vicarious liability? And so that's something we're taking a look at now, and we're in talks with PACE to see, is this an opportunity for us? Now that there's a new FCC, we've got a new administration, maybe this is a way to enhance compliance, but using the carrot versus the stick.
Yeah, and so, it would be interesting to, and it's an idea that we're floating and would love feedback on it. If we filed a petition for declaratory ruling around as Holly said, we've said what types of things could lead to vicarious liability, what things would not lead to, or would break that chain of vicarious liability if you did the types of things that were contained in the Daines Amendment. So we'd love feedback on that. We'd love your involvement in that. Government Affairs is debating this type of thing right now. So that kind of brings us to the end. Are there any questions? Reed, you're not allowed to ask any questions. This is going to cost you.
Okay, I'll pay. So can vendors be held vicariously liable for the acts of the sellers?
So the vendors, so give me a scenario. So are we talking about like bad scripting or?
So yeah, of course, something like that. So the vendors hired, they use the seller's CRM tools, they use the seller's dialer, but the scripts are also provided. Scripts are, would violate perhaps the FTC or FCC, maybe even some state laws. The call recording disclosure may not be made. Some of those types of things where there's errors in the process. So could a vendor be held liable when they're just busting seats in front of a computer?
Yeah, so my primary thought on that, Reed, is that, specifically with the TCPA, you're talking about primary liability at that point. They don't really have to get to vicarious liability. As the entity that makes the call, there's typically liability there. Now, you may have certain contractual requirements between the vendor and the seller and allocate the risk that way. So there's certainly ways to protect the company, but from a pure, the consumer sues, could you be held liable, at least with respect to TCPA, you know, the answer is they don't really need to get the vicarious liability, they just do it under the direct liability.
And then under the TSR, we'd be looking at assisting and facilitating. And did you know, or should you have known, that that script that you are using violates the law? I'm not worried so much about private right of action there, but certainly worried about the FTC or AGs bringing an action under that.
I'm a recovering lawyer myself, but it seemed to me that at a certain point in your comments that the courts might be slipping toward a theory of strict liability, by pushing vicarious liability to the limit on the part of the seller, which is the way the law sometimes goes in order to protect plaintiffs and saddle the defendants with all the responsibility and the liability. But then the narrative that you were talking about seemed to change. And I was particularly encouraged that a circuit court like the Ninth might actually come up with a reasonable, interpretation, because we veered away from that on the vehicle service plan. So I was just wondering, in terms of your thoughts for the future and where this all sits, it seems that at the end you're pretty confident that things are not going to go crazy and they'll remain fairly reasonable for the foreseeable future. Is that a fair statement?
I think the reasons that our comments kind of got tempered towards the end is, it's why I started out by giving you the factual scenario with Dish Network. Bad facts make for bad case law, right? So here with Dish Network, we had bad facts. It was the wild, wild west. And now granted, they went back all the way to 2003, and think about what we've learned from 2003 to 2017 when this decision came out. So that's why I wanted you to really understand how bad it was. There were millions of violations, and there was no action taken to try to prevent future violations from happening for do not call and other types of violations, calls to cell phones, all those types of things. But the point, what you really need to walk away from here with is you have got to really consult with people that understand these concepts of agency theory to design a program to the greatest extent possible to minimize agency. It's not any one factor in the Dish Network case that led to the court ultimately finding a parent authority or finding a parent agency. It was the combination of all of those types of things. Now, could one of those things have been removed and changed the scenario? Probably not likely in the Dish Network case, but maybe removing those with not such bad facts, it would be enough. You really just have to look at that totality of the circumstance and put the types of things in that are in that list that Nick was talking about that we've seen as common themes in the cases that are being decided now and have been decided since the 2013 declaratory ruling.
Yeah,
That's a takeaway.
Yeah, I agree with that. I think the one thing I would maybe add is that the cases are a little bit all over the place, but I do think that's to be expected because the facts are all over the place, which is what Michelle's talking about. But I do think they give us a little bit of a roadmap to how to, at least in today's environment, best protect ourselves. It seems like most companies are going to take too much control or take no control at all. And really it's finding the balancing act that we've been talking about this whole time. And there's no clear-cut way to do that right now, which is certainly why do things like the FCC input and things like that would be helpful. But at least there's some cues that we can draw upon to hopefully find that right balance. But I think you're seeing a little bit of reasonableness restored in this. That is at least a little bit encouraging.
Good question.
I just had very quick, did the Dish Network case talk about what the scope of the authority was? Like, I heard what it wasn't, but was there anything definitive as to what the scope of those retailers was?
Their scope of authority to act on behalf of Dish? The court didn't really focus too much on that, but they definitely had the authority to engage in those telephone calls, to make the sales, and then they did that using the means and methods that they did that were not lawful. So they said that they were acting within the scope of what Dish allowed them to do because that's what they were asked to do. All right, thanks guys. Thanks for staying.
Hi everybody, that's the end of our business for today, but it's not the end of the day, okay? Being here